Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. Every immigration firm has one. You know, the person who remembers every deadline, who keeps clients from spiraling, who knows exactly where the missing document is. I'm talking about the person everyone turns to when things get complicated. Usually, it's paralegal. And usually they don't get nearly enough recognition for the work that they do. The podcast's friends at eMigration are trying to change that with the Heroes Spotlight, a campaign celebrating the top immigration paralegals providing the backbone of immigration law. If someone in your practice deserves that spotlight, nominate them before September 25th. Go to get.eimmigration.com/IRP and give credit where credit's due. Special link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and is intended to keep you up to date and enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. What a week of cases, guys. So much so that I had to do my very rare top of the episode roundup of other cases, which you'll hear in just a sec. If you've enjoyed the Immigration Review podcast this year, give the podcast and its sponsors some love. Link at the show notes. Hope you enjoyed that Ira Kurzban interview too, the annual Supreme Court roundup. He has a way of terrifying, humoring, and inspiring me all at the same time. Hope you feel the same. Also, new book, 20th edition, coming out this September, I believe. Pretty impressive. And so here you go, folks. Case Law Week number 326 in a row. Starts now. All right, so here's that immigration roundup of removal proceeding adjacent cases that are still really important that I promised I'd do in the intro, if you listen to the intro. First, Mahdawi v. Trump, published by the Second Circuit. The court determined that there was no jurisdiction to bring a habeas petition in district court that addressed a question, in this case related to targeting Mr. Mahdawi based on his First Amendment speech that could be raised in the removal proceedings by virtue of I&A Section 242b-9. Under the Second Circuit's theory, the issues raised in the habeas were the same as those that arise, quote, from any action taken to remove Mr. Mahdawi, end quote, and therefore may only be brought as part of a petition to review the final order of removal. And of course, under this theory, the person remains in detention for weeks or months and sometimes years while the removal case progresses. The Second Circuit does state, though, that Mr. Mahdawi could have asked for a matter of Joseph-type hearing, arguing that he should not have been mandatorily detained, and I guess then speed up the adjudication of the I&A provision. 237A4C case, the Rubio letters. So not great for non-citizens, very bad in the Second Circuit. But then later this week, in Suri v. Trump, the Fourth Circuit took a different view and found that I&A Section 242b9 and Jennings v. Rodriguez do not preclude a separate habeas petition to challenge the government's unlawful detention of Dr. Suri because of his public opposition to the war in Gaza. Judge Wilkinson dissented. This case is very important because it also addresses the government's conduct in sending detainees to various locations and constantly moving them from one state to another without formally disclosing their whereabouts so that a diligent lawyer would not know where the person is incarcerated at any given moment. In this case, counsel reasonably thought that Dr. Suri was still in Virginia when he was bouncing back and forth to different locations, but at the time of the filing of the habeas, he was on a flight and landed in Alexandria, Louisiana. The government moved to dismiss because Dr. Suri was not in Virginia at the time that the habeas was filed. The district court, upheld by the Fourth Circuit, found that there were two applicable exceptions to the general rule that habeas must be filed in the district of confinement. First, the unknown custodian exception that protected Dr. Suri's habeas in Virginia because at the time of filing he was held in the undisclosed location of an unknown custodian. Second, Justice Kennedy's concurrence in Padilla. That's another exception to the district of confinement rule. Quote, if there is an indication that the government's purpose in removing a prisoner were to make it difficult for this lawyer to know where the habeas petition should be filed, end quote, or if, quote, the government did inform the lawyer where a prisoner was being taken but kept moving him so filing could not catch up to the prisoner, end quote, you have an exception. And that's the Rumsfeld v. Padilla decision from the Supreme Court. Finally, ending our roundup, on Friday of this week, the Fourth Circuit published Fuentes v. USCIS, which affirmed USCIS's decades-long interpretation of the statute and regulation that excludes the parents of SIJ recipients, special immigrant juvenile recipients, from receiving immigration benefits. That is, the parents from which the special immigrant juvenile was deemed abandoned or neglected or what have you, cannot themselves receive certain or maybe all immigration benefits. I know, pretty short summary of that last Fourth Circuit decision, but look guys, this is what happens when you issue your statutory interpretation-heavy removal proceedings adjacent decision on a Friday afternoon where I've already got 9 full case summaries. Live and learn, Fourth Circuit. And that is the Extra Case Roundup. Our first case is Rana v. Blanche, published by the First Circuit on July 23, 2026. This case is about mental health and credibility. Mr. Rana is from Nepal and, quote, was active in the National Democratic Party, a political party that supported the constitutional monarchy in Nepal, end quote. He was threatened and beaten by Maoists because of it. He was hospitalized after being hit in the head with a gun, leaving him unconscious. He sought asylum in the United States on this basis, but was denied by an immigration judge based on an adverse credibility finding. The IJ identified discrepancies in the testimony. When asked about the discrepancies, Mr. Rana, quote, testified that he was unable to remember certain events because he was nervous and that he had not been treated for memory issues. The IJ then granted Mr. Rana a continuance so that he could obtain a mental health evaluation to determine whether a medical condition caused the discrepancies in his testimony, end quote. Nice judge. And 6 weeks later, a licensed psychologist opined that Mr. Rana, while intelligent and understanding of what was happening in immigration court, quote, had trouble focusing, concentrating, and paying attention, and that his ability to assist his attorney and the immigration court was thus compromised, end quote. The IJ didn't believe that that was an adequate account for the inconsistencies and deemed Mr. Rana not credible. Indeed, reasoned the IJ, Mr. Rana's demeanor in court had indicated an inability to focus. The BIA affirmed the finding, particularly as Mr. Rana was represented by an attorney below, which the BIA regularly deems a very important mental health safeguard under matter of MAM. But the First Circuit did not agree. An IJ's obligations under matter of MAM, you see, really begin when the indicia of incompetency are present, and that includes a wide variety of things, explains the court. Quote, for example, an IJ might observe that the non-citizen fails to understand and respond to questions, stay on topic, or remain focused. Additionally, the record may evince the non-citizen's incompetency through medical reports or assessments, such as testimony from medical health professionals, end quote. If indicia are present, an IJ has an affirmative duty to consider the non-citizen's competency, even if, unlike here, counsel doesn't raise the issue. The affirmative duty to consider, I suppose, can be as simple as asking questions to probe about competency, or as much as sending out the individual for a psychological evaluation as occurred here, or I suppose even more. And if ultimately deemed incompetent, or partially so, I guess, an IJ must apply safeguards. The problem here to the First Circuit is that in this case, the IJ didn't actually conduct the matter of MAM inquiry. The BIA held that, quote, the IJ correctly declined to make a competency assessment because there were no such indicia, end quote. But that was not correct. There were indicia, explains the First Circuit. There's the head injury from 2012. Then the multiple times during the hearing where Mr. Rana could not recall details and testified to being nervous. Then there's that express mental health evaluation, right? The IJ needed to address it, make a competency assessment, and explain what safeguards, if any, were needed. The IJ could not do what the IJ did here, though, explains the court, just conclude that none of it changed the IJ's initial beliefs about credibility. Pursuant to matter of MAM, quote, these facts do not require the IJ to find Mr. Rana incompetent, but they do compel a finding that there were indicia of incompetency. The IJ therefore was required to articulate her assessment of Mr. Rana's competence or lack thereof, end quote. As to the demeanor stuff, well, quote, nothing precludes a person from showing a positive and attentive demeanor while still exhibiting indicia of incompetency, end quote. Nor does it matter that Mr. Rana was represented by counsel. That might matter as a safeguard, don't get the First Circuit wrong, I believe. But the duty to do the competency assessment and adjudicate appropriate safeguards, that's an affirmative duty that an IJ has to do once indicia of incompetency are present. Now don't raise the issue late in the game, though, non-citizens counsel. Don't play games, warns the First Circuit in a footnote. Ultimately, though, quote, competency is a distinct and antecedent question about credibility, end quote, and the matter of mom's safeguards, quote, may help to reframe or explain statements or conduct that could otherwise suggest a lack of credibility, end quote. Amen to that. And so it was remanded, and congratulations, Stuart Altman, for petitioner. And that is Rana v. Blanche. Five decisions from the BIA this week because it's another week. First one, matter of HLSM, published by the BIA. This case is about Convention Against Torture Protection. Someone decided to make it precedential in the acting attorney general's name. Didn't used to be. Surely because of a criminal history, Mr. HLMS is eligible only for cat protection from Guatemala, where he's from. And IJ granted it to him. And he also got cat protection from Mexico, which I guess is another country that DHS wants to remove him to. Quite the win. Error, of course, explains the BIA. He was a member of both the Latin Kings and MS-13 at points, and he testified against them in the United States. Testified against them at trial and everything. And while in prison himself, quote, a member of the Latin Kings ran into his prison cell, attempted to stab him, and threatened to kill him if he cooperated with law enforcement. He learned he had been placed on the Latin Kings' kill on-site list, which was also shared with gangs such as MS-13. He said he was placed in the witness protection program in prison and upon his release from prison. He said he was kicked out of the program after calling a friend, which was against the security protocol. He believes that gang members are looking for him, end quote. All of that happened in the United States. Anyway, cat protection was reversed, for you see, the IJ relied on country conditions and expert testimony. The BIA, in contrast, seems to want cat applicants to go to their country, nearly get killed or tortured, but escape, bring with them video of the near torture and escape along with a voice recording of the incident referring to them specifically, and the assaulted individual who would be identifying him or herself and their connections to that country's government, and then present that evidence to the IJ. Quote, notably, the applicant never experienced any past torture in either Mexico or Guatemala. This lack of past torture is a significant consideration when assessing the applicant's risk of future torture, end quote. Wild. Absolutely wild. This, of course, despite acknowledging that it would make little sense for past torture to have been suffered, given that Mr. HLMS's, quote, fear now stems from experiences that occurred in the United States, specifically having received threats from gang members because he cooperated with law enforcement, end quote. But you see, MS-13 hasn't threatened him directly, whatever that means, since his release in the U.S. And I see, MS-13 did threaten him indirectly by blaming Latin Kings members on social media and saying that they were going to get them, something Mr. HLMS believes relates to him. Too vague to the BIA. And it's been 15 years or so since that prison incident, notes the BIA. Mr. HLMS hasn't been attacked in the U.S. since that time, thank God, and somehow relevant to the BIA, though I can only imagine the BIA does not believe that the U.S. government is acquiescing to MS-13 and Latin King torture in America. Clear error is a high standard, and the BIA's credit, it says it's applying it throughout this decision. It next held that the IJ clearly erred in the IJ's weighing of expert testimony. Quote, the applicant's expert witness also testified that both the Guatemalan and Mexican governments have taken action to combat criminal organizations within their borders. While he stated that such efforts have not been effective, the fact that elements within the governments have attempted to combat the issues, which the IJ acknowledged in a summary of the testimony but did not address in the analysis, diminishes the likelihood that any future torture that the applicant fears would occur by or with the consent or acquiescence of a public official or other person acting in an official capacity in either country. End quote. That's pretty much it. So I guess Mr. HLSM is getting sent to Guatemala or Mexico. And that is a matter of HLSM. Moving on to a matter of AGOF, published by the BIA. On Tuesday, I noted that the BIA already had 2 decisions by Tuesday. What I didn't know is that it would last through Friday. This decision also didn't used to be precedential, but now it is. It's about a Brazilian family who an immigration judge had the audacity to grant humanitarian asylum to. The BIA has reversed that. Quote, the lead respondent was physically abused as a child by his mother and uncle, and he was drugged and raped as a child by 2 men. End quote. An IJ held that it occurred on account of his membership in one or all, I guess, of the following particular social groups. 1, family unit. 2, family of respondent's biological father. 3, Brazilian children. And 4, abandoned Brazilian children. Past persecution then, of course, but DHS rebutted the presumption because now the lead respondent is an adult, though actually the ruling was that he could relocate in Brazil. Either way, no well-founded fear of future persecution because DHS rebutted the presumption. Humanitarian asylum exists, though, precisely for such cases, and the IJ granted it. A few things required to get humanitarian asylum, and unfortunately it's not discussed in this case, given that it was never intended to be precedential. But one of the things is that you have to have suffered past persecution, meaning that the harm had to be on account of a protected ground. And that is where the BIA attacked. The BIA agrees with DHS that the groups Brazilian children and abandoned Brazilian children are not cognizable because they are not defined with sufficient particularity. We have yet to find a BIA decision in Trump 2 where they actually find a proffered particular social group cognizable, I believe. Quote, Brazilian children is not defined by discrete terms as it encompasses children of different races, ages, and other personal characteristics, and therefore comprises a large diffuse portion of Brazilian society. End quote. The BIA also explains that the term abandoned is not adequately defined within the record evidence and, quote, does not provide an adequate benchmark for who falls within the group abandoned Brazilian children, end quote. Nor does the BIA believe that this happened by individuals that the Brazilian government was unable or unwilling to control. Let's step back, though. He was a kid who was abused, drugged, and raped, presumably repeatedly, and so, by definition, the Brazilian government was unable to control them. The phrase is unable or unwilling, not unable and unwilling. And the BIA ostensibly, quote, continues to observe that it may be futile or dangerous for an abused child to seek protection from the authorities, end quote, citing matter of CGT, which they're probably itching to vacate. However, reasons this BIA, the Brazilian government arrested one of the men in connection with other crimes. Seems marginally relevant to me, but treated as pretty dispositive in this decision. Quote, furthermore, the Brazilian government provides services for abused children, such as a national hotline to allow authorities to protect children, end quote. Clear error by the IJ. Now, naturally, the BIA affirmed the IJ's finding that DHS rebutted the presumption of a well-founded fear of future persecution because the lead respondent could relocate. And for these reasons, the BIA sustained DHS's appeal, reversed the grant of humanitarian asylum, and sent this family's case all back into the ether of EOIR. And that is a matter of AGOS. Moving on is a matter of YSPT, published by the BIA. This case is about extreme hardship. Didn't used to be precedential, now it is, and it's actually occurring in the motion to reopen context. The BIA previously affirmed denial of an asylum claim here. Mr. YSPT now seeks to reopen to pursue adjustment of status because he's married to a U.S. citizen, and USCIS has approved his spousal petition. He included his adjustment of status application as required for motions to reopen, and he included an I-601 waiver too. For you see, Mr. YSPT has crimes. They can be waived, though, with an INA Section 212H waiver in conjunction with an adjustment of status application. The BIA often denies motions to reopen for failure to comply with its procedural rules or timeliness requirements. Apparently not at issue here, but the BIA found another reason. Quote, "We will deny the respondent's motion because he has not established a realistic chance he can establish eligibility for relief." End quote. That is, no prima facie showing. The convictions Mr. YSPT has are from 2019. 1. Sexual abuse in the third degree, under Section 130.55 of the New York Penal Law. 2. Forcible touch, intimate parts, Section 130.52(1). And 3. Forcible touch on a bus or train, Section 130.52(2). So yeah, no one's condoning those crimes. Not good stuff, not good at all. Now, usually a Section 212H waiver only requires a showing of extreme hardship to a qualifying relative, and remember, Mr. YSPT is married to a U.S. citizen. But when you have convictions, quote, involving violent or dangerous crimes, end quote, you have to show extreme or exceptionally unusual hardship to get a Section 212H waiver. The BIA holds here that these are such crimes. And even then, the regulation states that the waiver is all discretionary anyway. The BIA doesn't believe that Mr. YSPT established extreme hardship, much less that higher standard. Seems like he married while he was in immigration detention post-immigration judge removal order. Quote, "The respondent points to the ongoing mental and physical health challenges his wife has experienced and continues to experience. However, the respondent does not explain how his removal would result in increased hardship to his wife, as he has been detained since prior to the marriage. Additionally, to the extent the respondent points to financial hardships his wife may face, the respondent has not claimed any assets and submitted a fee waiver request with his motion to reopen." End quote. Nor in any event does the BIA believe that Mr. YSPT would warrant the relief as a matter of discretion. Not much analysis on that, just their sex crimes. Correctly citing matter of log, the BIA holds that Mr. YSPT, quote, has not demonstrated a reasonable likelihood of success sufficient to warrant reopening, end quote, and denied the motion to reopen. And that is matter of YSPT. Getting on to the big ones this week, published later in the week, is matter of Lopez Rizo, published by the BIA. This case is about pleading the fifth, and of course, discretion because it is the BIA in 2026. Mr. Lopez Rico is a lawful permanent resident from Mexico. He should have naturalized, but he didn't, and in 2012 he voted in the presidential election. That makes him part of an exceedingly small amount of non-citizens who did that, and I'll bet you like $1 million he did it by accident, believing himself allowed to as an LPR, and perhaps even doing his civic duty. Who knows, it's unstated, but I bet that's the case, I bet. He admitted to it, after all, when it came time to naturalize. USCIS still could have naturalized him. They chose not to, and chose to start removal proceedings, and now we're here. He was charged as removable under INA Section 237A3D, a false claim to U.S. citizenship, although I'm not sure if it was sustained. But the sustained charge was definitely INA Section 237A6, a non-citizen, quote, who has voted in violation of any federal, state, or local constitutional provision, statute, ordinance, or regulation, end quote. Mr. Lopez applied for LPR cancellation of removal. Totally eligible. And IJ denied it as a matter of discretion, and the BIA has affirmed that. The removability finding was challenged first, and it's about the unlawful voting. In matter of Fitzpatrick from 2015, the BIA held that a violation of 18 USC section 611A, which generally prohibits non-citizens from voting in elections in federal office, renders a non-citizen removable under I&N section 237A6. Quote, although DHS did not expressly cite 18 USC section 611A in support of the charge, the basis for removability was adequately identified in the record, end quote. Mr. Lopez admitted previously that he voted in a presidential election after all. That could only be one statute, appears to reason the BIA. Nor need DHS establish a mental state to take away an LPR's green card under this provision. Strict liability, no forgiveness. At least when it comes to Section 611A, I believe. Now true, the Ninth Circuit, quote, under whose jurisdiction this matter arises, has recognized that removability under Section 237A6 depends upon the elements of the underlying voting provision, end quote. And here, again, that's Section 611A. Probably why it's so exceptionally important for DHS to actually identify the statute that DHS, is alleging that the non-citizen violated to meet their clear and convincing evidentiary burden on removability. But the BIA is excusing that requirement here. Assuming, as the BIA does, that this is a Section 611A offense, well, Section 611A is simply a general intent crime. Criminal liability and therefore removability does not require proof that the non-citizen knew that voting was unlawful. I don't know, man. All seems so dang harsh to me, but a lot of that is Congress's fault, 1996. Still leaves LPR cancellation of removal, but the BIA is going to refuse to be nice to this longtime LPR who appears did not know that he was not allowed to vote all those years ago. Gotta balance the factors, explains the BIA. As always, the BIA recognizes the, quote, substantial, end quote, equities that Mr. Lopez presents, including his longtime residence, family ties, hardship to his family, which isn't even required, and many other things. Before, of course, the BIA rejects them. Because you see, Mr. Lopez has a DUI conviction from 2016 and a, quote, DUI-related, end quote, arrest from 2024 that is still pending. Might not eventually result in a conviction. IJs can rely on arrests during the discretionary analysis, explains the BIA, especially where they are recent. And when the IJ provided Mr. Lopez the opportunity to explain, well, he invoked his constitutionally protected right against self-incrimination and declined to answer material questions. Non-citizens can do that in removal proceedings. They're allowed, affirms the BIA. But as it has done in the past, if they do assert that constitutionally protected right, an IJ can draw an adverse inference against them, at least at the relief stage. It appears that an IJ cannot, quote, deny relief merely because the respondent invoked the privilege against self-incrimination, end quote. But an IJ can draw an adverse inference. In a footnote, the BIA all but says that this rule does not apply when we're talking about removability and where DHS has the burden. Indeed, as the Supreme Court has explained in Pareda, evidentiary gaps work against the party with the burden, and on relief, that's the non-citizen, explains the BIA. Now, the IJ recognized that there were mitigating circumstances on this voting, that Mr. Lopez was young, and the BIA all but says that it was an unfortunate misunderstanding and mistake. But unlawful voting is serious, explains the BIA. And so, issuing a rule that it did not have to do, but that is very harsh for non-citizens, the BIA concludes and states that, quote, consequently, unlawful voting is a significant adverse factor in determining whether discretionary relief is warranted. Given the seriousness Congress attached to such conduct and the governmental interest it implicates, the IJ could have afforded the respondent's unlawful voting violation greater adverse weight than he ultimately did, end quote. How about that? And that is matter of Lopez Riso. I know these BIA decisions are just things that you listeners wish would never end, but we must conclude with the BIA, and we do with matter of LFR published by the BIA. With this decision, the BIA has issued a decision adverse to non-citizens every single day this week. And astonishingly, given everything I just read, this one is probably the cruelest. Donald Trump's big bill created an annual asylum fee of $100, although I think it's $102 for the first time you pay it. Don't quote me on it. EOIR and USCIS did not provide guidance on how it would all be implemented, and it was complete chaos last fall. It was crazy. Hard to think that that was not intentional. As I understand it, USCIS has now been providing notice that the fee is due every year, although we'll see if that continues. Immigration courts have not, and I can only imagine don't really intend to. The fee can be paid in about 30 seconds online if it's missed. But should non-citizens be given that opportunity, or should they be summarily deported to the country from which they fear based on a $100 oversight that they can remedy in about 30 seconds? You know it's the latter. That's what the IJ did here, and that's what the BIA has affirmed. Now, in fairness, the IJ expressly set a deadline, in this specific case, for the asylum fee to be paid by a date certain. The respondent missed it. Don't know why. And the individual hearing had not occurred yet. This is all happening well before the individual hearing. But rather than give another chance, the asylum seeker got ordered removed. Is the scheduling order, that is the specific date to pay it, a material element to this new rule that the BIA has instituted? We shall soon find out. I absolutely refuse to name Mr. Trump's bill that created this asylum fee because it is just such an unbelievably stupid and embarrassing name for a law, and I physically cannot say it. So I'll call it the OBBBA, like the BIA does. And to the BIA, in the OBBBA, quote, Congress has plainly stated that the Attorney General shall require the payment of a fee, end quote. Doesn't necessarily mean, though, that you necessarily have to automatically terminate asylum without any remedy if the annual fee isn't paid, right? Well, quote, it is well established that IJs have the authority to set filing deadlines, end quote. As such, quote, IJs can set deadlines for paying the annual asylum fee, and if a non-citizen fails to pay the annual asylum fee within the prescribed deadline, the non-citizen's asylum application should be pretermitted or deemed abandoned, end quote. So that seems to be a rule. Seems then that the ability of an IJ to deny asylum for failure to pay an annual fee depends on the IJ having set an express deadline. Though I suspect we might start seeing generic scheduling orders that simply say that the respondent must pay the fee every year, and that are then relied on to deny asylum when the deadline is missed, say 3 years from the scheduling order. I don't know, not advocating for it. I'm just not loving what I'm seeing out of the immigration courts these days when the BIA issues these new procedural rules. The BIA can do this too, by the way, explains the BIA. And that's pretty much it on the asylum fee. This rule does not extend to withholding of removal and cat protection, though. The reason, explains the BIA, is based on some statutory interpretation of the OBBBA, applying only to asylum rather than the I-589 form itself, and withholding of removal and cat protection are meaningfully distinct from asylum. Very relevant to INA Section 237A4C, removability, which is on my mind at present, that is the Secretary Rubio letters, quote, the Supreme Court has repeatedly cautioned against reading words, elements, or implied exceptions into a statute, end quote. If you have a Section 237A4C case before you, a Secretary Rubio letter, and you're wondering why I think that quote is important, hit me up. Nor does DHS's regulatory argument trump what the BIA believes is the plain text of the statute as regards withholding of removal and cat protection. Also a relevant analysis for Section 237A4C issues, hit me up. Back to asylum. And while cruel, I'll concede that the BIA tempered its holding a bit, and so we'll take back some of what I said at the top of this summary. Quote, the immigration judge set an appropriate deadline such that the respondent had sufficient notice and opportunity to pay the annual asylum fee. What constitutes enough time is a case-by-case determination, which is based on the specific facts and circumstances of each individual case. Here, the IJ gave the respondent sufficient notice and opportunity to pay the annual asylum fee, end quote. I can only imagine that such a rule, after notice and opportunity to file, will apply to DHS when IJs give DHS a filing deadline. Asylum terminated, but the case was remanded for withholding of removal and CAT analyses. And that is a matter of LFR. You didn't go to law school to enter data. I know I didn't. Yet here you are, H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. Because you deserve a practice that grows without burning you out. Okay, we're back with Garcia Demetrio et al. V. Blanche, published by the 9th Circuit on July 20th, 2026. This is a breath of fresh air about gender-based particular social groups. Miss Garcia and her 3 minor children are asylum seekers from Mexico. Her husband disappeared without a trace in 2023 and remains missing, and the family fled to America. Miss Garcia didn't flee immediately, though. First, she appeared at what she was told was a government office to receive financial assistance. Instead, when she arrived, the people who had said that they were government officials at first tried to kidnap her and force her and her children, essentially, into slavery. They were going to make the son traffic drugs and might do the same to the daughters and rape them. If Miss Garcia refused, they'd kill them all. She fled immediately to Mexico City and then America. After all, quote, criminal organizations in Mexico routinely force adolescents to sell and transport drugs on their behalf, and adolescent girls are particularly at risk of sex trafficking, end quote. And IJ and the BIA denied the asylum claims. The agency held that the particular social group mothers of adolescent children living in Mexico is not immutable, and that the particular social group single women targeted by criminal groups in Mexico lacked a nexus to the persecution that Miss Garcia allegedly suffered and feared. Remanded by the 9th Circuit. Quote, if a proposed particular social group lacks sufficient immutability, particularity, or social distinction, the particular social group is legally non-cognizable, and relief may not be granted on account of an applicant's membership in that group, end quote. Of course. But the 9th Circuit addressed mothers of adolescent children living in Mexico first. The BIA had reasoned that the children will age out eventually, so the group isn't immutable. They won't be adolescents forever, right? But that is not correct. I mean, that is correct, but here's why it's not correct. Quote, one's age or the age of one's child is not within an applicant's ability to control, end quote. And that is kind of the rationale used for immutability. And heck, matter of SEG itself grappled with an age-based group and held that it could be immutable. Smart arguments, counsel. Applying to the BIA's decision here, quote, the mutability of age is not within one's control, and if an individual has been persecuted in the past on account of an age-described particular social group or faces such persecution at a time when the individual's age places him within the group, a claim for asylum may still be cognizable, end quote. Though the 9th Circuit no longer need defer to matter of SEG or anything else under Loper Bright, quote, the agency's body of experience and informed judgment may give those interpretations the power to persuade, end quote. Particularly when thorough and well-reasoned, as the 9th Circuit believes matter of SEG was, as that decision did rely on 40 years of BIA precedent. Lots of circuits, USCIS trainings, and more all recognize that age can be immutable. Going through the 7th Circuit precedent, 4th Circuit precedent, and other courts, the 9th Circuit states, quote, these decisions are each consistent with long-standing BIA precedent and with international understandings of asylum law, end quote. Citing de Deborah Ancor's Law of Asylum in the United States Treatise, 2026 edition. Not only that, the 9th Circuit itself has upheld age-based particular social groups, albeit without much analysis. The 9th Circuit hasn't been entirely consistent on it, it admits. So in this decision, the court holds that, quote, age-based particular social groups are immutable as a matter of law because asylum applicants cannot alter their age to escape persecution, end quote. Now, that doesn't mean it's necessarily a particular social group, but it does mean it appears that you necessarily get past element 1, immutability. And of course, you might run into materially changed circumstances arguments as that person ages. That said, quote, because age-based particular social groups are immutable, so too are particular social groups defined by an immutable relationship to a young or adolescent child, end quote, as was the case here. Remember, we're talking about the mother, Miss Garcia. So remand. But that's not all. Ms. Garcia also has a claim based on her membership of the particular social group single women targeted in Mexico. Ish. The BIA had held that the IJ didn't clearly err in finding no nexus. But Ninth Circuit precedent holds that the BIA must review the IJ's no nexus determination de novo. So there you go. That's the Umana Escobar decision, by the way, episode 151. Woot, woot, woot. Meaning congratulations, Shannon J. Murphy and Destiny Soto for petitioners. And that is Garcia Demetrio et al. V. Blanche. Sticking with the Ninth Circuit, we have Diaz-Boizo v. Blanche, published by the Ninth on July 23, 2026. This case is about crimes of child abuse, abandonment, or neglect. The panel starts out by explaining that Mr. Diaz-Boizo was convicted of physically assaulting his wife in front of their minor children under then Oregon Revised Statutes Section 163.161A and 3C. That code has since been renumbered, so today that latter is subparagraph 3A, not 3C, explains the court, but we're going to go with 3C throughout this decision. Mr. Diaz has been a lawful permanent resident for a very long time and should have naturalized. He's getting ordered removed because he didn't. And of course because of the conviction. DHS charged him as being removable for having been convicted of a crime of child abuse, child neglect, or child abandonment. Kind of a creative charge to me. And I wonder why they didn't bring an aggravated felony crime of violence allegation. He's got the years of imprisonment. I imagine DHS believes it has a categorical approach problem with this Oregon statute. And yes, based on the mens rea discussion we're about to get into, I bet that's the case. But this is obviously not about harm to the kids per se. They just witnessed what he did to the mother. And the Oregon assault statute is obviously broader than the federal offense of a crime of child abuse. Not all of it, or indeed most of it, relates to children. But the statute becomes a Class C felony if one of four things occurs. Subsections A, B, C, and D. Subsection C was the subsection here, if you recall, and that reads, quote, the assault is committed in the immediate presence of or is witnessed by the person's or the victim's minor child or stepchild or a minor child residing within the household of the person or victim, end quote. So there's your child connection. The argument, therefore, came down to divisibility. Mr. Diaz argued that the subsections A, B, and D are not elements of the offense, making the whole thing not divisible, meaning you can't actually find that there's a nexus to a child because it could be A, B, C, or D. And after all, by definition, elements A through D all get you the same punishment, right? The whole point is that any one of the four make it a Class C felony. That's actually my argument just reading this decision, not Mr. Diaz's. He's got other good arguments. But he's also got a problem, because the Ninth Circuit reads Oregon state court law as, quote, recognizing that each is the disjunctive element the state must prove, end quote. Pretty bad for a no divisibility argument. And the jury instructions confirm that, as applicable, quote, the state must prove, beyond a reasonable doubt, that the assault was committed in the immediate presence of or witnessed by a minor child, end quote. Mr. Diaz countered that Oregon has an anti-merger doctrine, quote, which limits the state's ability to obtain multiple convictions for the same conduct, end quote. That is, it's kind of a double jeopardy concern. If they were separate elements, they'd be separate crimes, and so the state could obtain multiple convictions if a defendant committed, say, a subsection C and subsection A offense. Sounds like a good argument to me, and both the BIA and the circuits have approved of it in the past, at least to find a statute divisible. The panel rejects it here to find it indivisible, fairly summarily without much explanation. Not least of which because, as well, it appears that the indictment and plea agreements were specific as to the subsection of conviction and the facts, which included mention of the kids. One last question, though. Is doing this to your adult spouse in front of your kids child abuse? It is, explains the court. Quote, committing an assault in the immediate presence of a child places the child in real danger of bodily or mental harm, end quote. Lots of case law, too, that children need not be actually harmed for this removability provision to apply, though the case law does develop in the context where the child is he or herself the focal point of the crime, just saying. As to the mens rea required, the statute requires at a minimum criminal negligence as to the presence of the child. Good enough for child abuse removability, explains the court. Kind of complicated. All of that is because, quote, while Section 163.163C doesn't specify a requisite mens rea for its aggravating elements, Oregon's general culpability statute ensures that any material element of a criminal statute that lacks a stated mens rea has one imputed to it, end quote. And Oregon law puts the lowest possible mental state as criminal negligence. And for all those reasons, the Ninth Circuit affirmed the removal order. And that is Diaz-Boizo v. Blanche. We conclude with Torres-Casas v. Blanche, published by the Ninth Circuit on July 22nd, 2026. Pretty harsh one about non-LPR cancellation of removal. Mr. Torres-Casas is from Mexico and has lived in the United States for a long time. In removal proceedings, he applied for non-LPR cancellation removal based on the exceptional and extremely unusual hardship that he claimed his U.S. citizen son would suffer if he was removed. He also has a U.S. citizen daughter and LPR parents. The immigration judge denied the relief, and at the time that the IJ denied, the son was 20 years old. Mr. Torres appealed, and of course, during the BIA appeal, the son turned 21 years old, meaning he was no longer a child for immigration purposes. So this is a not very sympathetic factual or procedural context for this important legal rule to present itself before the Ninth Circuit. The BIA dismissed the appeal, holding whatever happened below, Mr. Torres-Casas no longer had a qualifying relative anyway. That's a matter of Isidro Zamorano, published by the BIA in 2012. The Ninth Circuit affirmed that. To recap, the INA defines the term child as, quote, an unmarried person under 21 years of age, end quote. Non-LPR cancellation of removal, in turn, requires in relevant part that the non-citizen establish, quote, that removal would result in exceptional and extremely unusual hardship to the non-citizen's spouse, parent, or child, who is a citizen of the United States or a non-citizen lawfully admitted for permanent residence, end quote. Some more law, explains the Ninth Circuit. No matter who wins, if a BIA appeal is taken, the IJ's decision is stayed. It's for this reason, for example, that you don't have a final order of removal while a timely filed BIA appeal remains pending. And at this point in the decision, we learn that Mr. Torres-Casas does have quite a few other qualifying relatives, the daughter and the LPR parents. I just remembered that from when I read the case. But the BIA didn't believe the hardship to the U.S. citizen daughter or the LPR parents bad enough. Seems like the daughter was also 21 by the time that the BIA ruled, and the BIA missed it, notes the Ninth Circuit. Now, in 2016, in Mendez-Garcia v. Lynch, the Ninth Circuit essentially deferred to the Isidro Zamorano rule. The Ninth Circuit says that's still good law, even after Loper-Bright, relegating that important, but increasingly rejected, legal argument to a terse footnote. That's how the Ninth Circuit reads Mendez-Garcia anyway. Mr. Torres actually argued that the case could stand for the proposition that the qualifying relative's age is fixed at the time that the IJ decides the case, but the panel rejected that reading of this 10-year-old decision. Regardless, the panel took the opportunity to decide the issue once and for all post-Loper-Bright. On hardship, quote, because the statute is framed in conditional terms, would result, it requires an adjudicator to make a prediction about the future, end quote. And while the statute doesn't preclude a rule that the qualifying relative's age could freeze at the time of IJ adjudication, the Ninth Circuit panel believes that the best reading of the statute requires that the non-citizen have a qualifying relative at the time the agency decision is finalized. And that, friends, is when the BIA rules. Now, mind you, with the 4,000 grant cap and the delay in deciding BIA appeals, there could legitimately be like a 6 to 8 year wait between when an IJ decides that a non-citizen established sufficient hardship to a qualifying relative and the BIA's resolution of DHS's appeal. To take another hypothetical. No mention in this decision that I can see of when exactly the IJ makes a decision for qualifying relative purposes. Is it when they adjudicate eligibility, or is it like 3 or 4 years later when a number becomes available and the IJ, in a usually pro forma manner, actually finalizes the grant? While the court does state, quote, it is true that those applicants' eligibility will be destroyed by the passage of time through no fault of their own. That arbitrariness is a serious concern, but interpreting the statute to avoid that result would require a departure from the text. And as the Supreme Court has explained, the possibility of a harsh outcome cannot justify reading absent words into the statute, end quote. Not absurd enough for the court. Also, truly terrifying logic, quote, because the agency has virtually unfettered authority to deny relief regardless of eligibility, it has little incentive to drag its feet for the sole purpose of rendering applicants ineligible, end quote. Flip side, though, quote, by the same token, the agency must account for new qualifying relatives, such as a new spouse or a newly eligible parent, end quote. Must seems an important mandatory word there to me. And a, quote, applicant can gain a qualifying relative if his U.S. citizen child is born during his appeal to the BIA, end quote. Actually pretty helpful for BIA motions to remand. While the BIA can take administrative notice of a child's age, quote, the BIA may not determine a petitioner's eligibility based on new material facts that are not subject to administrative notice, such as an alleged change in the severity of a qualifying relative's medical condition. In that circumstance, to comply with the agency's regulation and to meet its statutory obligation to ensure its hardship determinations are based on the most up-to-date information, the BIA generally must remand to the IJ for further fact-finding, end quote. Seems like there's something to work with there. Back to the direct issue at hand, though, Congress has been clear when it wants to freeze a child's age, such as with the CSPA, explains the court, and it did not do so with non-LPR cancellation of removal. So, too, Congress froze the accrual of 10 years continuous physical presence required for non-LPR cancellation, albeit in a manner adverse to non-citizens, freezing it when a non-citizen commits a disqualifying crime or the service of a notice to appear. No freezing, though, with the qualifying relative's age in the statute. No mention by the court of Perez v. Bondi, published by the Sixth Circuit, episode 292, so I'm hesitant, but near certain that this decision enters a circuit split on this age-out issue, and so we're giving it a gong. Having disposed of the hardship to the son, the Ninth Circuit turned to the LPR parents, who of course cannot age out, although they can die, but they did not do so here, so they are qualifying relatives. Ordinary hardship, explains the panel. Numerous reasons. Mr. Torres would, quote, continue to support his family financially from Mexico to some extent, and that because most of his family members were employed, they could otherwise support themselves. Moreover, the agency found that Mr. Torres would be able to maintain his relationships with his family members and that they could visit him in Mexico. Finally, the agency acknowledged Mr. Torres' mother's health problem, but it found that Mr. Torres' removal would not meaningfully interfere with her ability to get medical care, end quote. And for those reasons, the court affirmed the BIA's denial. And that is Torres Casas v. Blanche. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Aww. Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.